A trust is a legal agreement between the originator, called the grantor, and the trustee, wherein the grantor transfers legal title of assets to the trustee, and the trustee holds legal title for the benefit of the trust beneficiaries. By splitting the beneficial enjoyment of trust assets from their legal ownership, a trust allows a debtor to give up legal title while retaining beneficial enjoyment and possible control over the assets. Because it is impossible to bulletproof a debtor, asset protection involves structures and techniques like trusts that make it more difficult and expensive for a creditor to reach a debtor's assets. The objective is to change the creditor's economic analysis, making the pursuit so difficult and expensive that the creditor will either give up or be willing to negotiate on terms more favorable to the debtor. In 1981, Fannie Mae issued the first mortgage-backed pass-through security. Securities world would never be the same. What this did was turn the promissory note of a single-family homeowner or commercial property owner into the same paper as stocks and bonds through the use of trust law. The Securities and Exchange Commission became the watchdog over the once promissory notes, now merged into massive pool to back up the investors. 18 years earlier, Florida passed a trust law as well, known as the Florida Land Trust Act. This law allowed a Florida property owner to turn their real estate holdings from real estate into personal property. The two actions have one common denominator. Trust law changes the nature of what property or its value are seen as by the legal system. Florida land trusts are a very powerful asset protection tool for the Florida real estate owner. A Florida land trust, unlike a state-regulated corporation, PA, or an LLC, is not registered with the state. There are no public records of officers, directors, or shareholders. There are no minutes of directors or shareholders' meetings. The trustee keeps control of the trust records and the identity of the beneficiaries in his file cabinet. A trustee does not have to reveal beneficial interest holder information to anyone. Once a property is converted to a Florida land trust, it is no longer considered to be real property, nor is it governed by land law. Rather, land trust property in Florida is considered to be personal property and is governed by the Florida statute version of the Uniform Commercial Code. The land trust arrangement consists of the land, the trustee, who holds the title, and the beneficial interest holders who hold the use, either individuals, corporations, or public entities. The United States is the largest land trustee, holding more than 26 million acres of land for Native Americans in trust. In 1963, Walt Disney World was the first corporation to create and hold land trusts in Florida. 2013 is the 50th anniversary of the passage of the Florida Land Trust Act, Florida Statute 689.071. Only 4 other states, Illinois, Hawaii, Indiana, and Virginia, offer both the flexibility of a Land Trust Act and the courtroom seasoning that makes it effective. A trust is a flow-through entity for tax purposes. The IRS doesn't require you to have an EIN number for the trust, as long as the trust falls within a few exceptions for doing business. And for the most part, all of your land trusts will fall into at least one of those IRS exceptions. Your tax accountant should check for you, but for the most part, if you have a land trust for properties, you will not need an EIN number. The property's financials will be included in your personal tax returns. The usage holder is not important here, just the person or entity who enjoys the benefits from the trust. In subsequent briefings, we will present good reasons to consider converting Florida property into Florida land trusts. In today's information age, anyone with an internet connection can look up your ownership of real estate. No one knows what one's bank balance is or one's stock investments are, yet anyone with an internet connection can look up a person's real estate holdings. Privacy is extremely important to most people who don't want others knowing what they own. For example, if you own several properties within a city that has very strict code enforcement, you could end up being hauled into court for just too many violations, even minor ones, because you have multiple violations. Having your real estate titled in a Florida land trust makes it difficult for city code enforcement to find who the owner is, since the trust agreement is not public record for everyone to see. And it is each individual trust that owns the property. A significant benefit of the Florida Land Trust Act is its ability to provide you with protection from liens against the property. Real estate titled in a trust name is not subject to liens against the beneficiary of the trust. For example, if you are dealing with a seller in foreclosure, a judgment holder or the IRS can file a claim against the property in the name of the seller. If the property is titled into trust, the personal judgments or liens of the seller will not attach to the property. Successor beneficiaries are those who inherit trust ownership following a life or health event. They may make and direct the disposition of beneficial interest upon the death or incapacity of the named beneficiary. These directions to, for example, buy, sell, or trade might occur by providing in the trust agreement for the successors with actionable privileges. The provisions for successors has been held not to be testamentary by the court, which means that they are out of reach to non-beneficial interest holders, unlike those interests that might be found in a will. Since the interest of a beneficiary is personal property, marital rights do not apply as well. Therefore, title can be conveyed without the joinder of the spouse. In other words, even though a spouse had signed off on the mortgage lien and title, if the land trust conversion occurred and one of the spouses died, the other spouse does not have to prove the death to a court to sell the property. A Florida land trust can provide protection from title claims. If you as an individual sign a warranty deed in your own name, you are subject to potential title claims against you if there is a problem with title to the property. For example, a lien filed without your knowledge could result in a liability against you, even if you purchase title insurance. A land trust in your place as seller will protect you personally against many types of title claims because the claim will be limited to the trust. If the trust already sold the property, it has no assets and thus limits your exposure to title claims. A Florida land trust will discourage litigation. The Florida Land Trust Act allows trust holders to exclude the value of property held in the land trust from their personal worth statements. Let's face it, people tend to only sue others who appear to have money. Attorneys who work on contingency are only likely to take cases which they can not only win but collect, since the fee may be based on collection. If your personal worth in properties are hard to find, you will appear broke and less worth suing. Even if a potential plaintiff thinks you have assets, the difficult prospect of finding and attaching these assets will discourage litigation by the attorney against you. A Florida land trust can provide protection from homeowner association claims. When you take title to a property in a homeowners association governed community, you become personally liable for that property's maintenance, all dues and assessments by the HOA. This means if you buy a condo in your own name and the association assesses an amount due, they can place a lien on the property and or sue you personally for the obligation. In Florida, first take title in your name at closing. Then you can convert your title into a land trust so that the trust itself, and thus the property, will be the sole recourse for the homeowners association's debt collection, code warnings, or liens. A Florida land trust makes contract assignability feasible. The ownership of a land trust, called the beneficial interest, is assignable, similar to the way stock incorporation is assignable. The difference is that the beneficial interest holders must at all times be active participants in the direction of the actions of the trustee, while stockholders are simply passive investors. Once property is titled in trust, the beneficiary of the trust can be changed without changing title to the property. This can be very advantageous in the case of a real estate contract that is non-assignable, such as in the case of a bank-owned or HUD property. Asset managers at financial institutions should be well aware of the Florida Land Trust and will often refuse to sell to a land trust buyer for just this reason. So the steps are twofold. First, buy the property in your name. Next, convert the property to a land trust. Subsequent activities or your decision. Always consult an attorney before making a legal decision. A Florida land trust converts real estate into personal property. There are significant legal ramifications in the conversion. Financial institutions have been changing the good faith and credit of homeowners into equity stock called mortgage-backed securities for decades. Under the regulations of the SEC, a licensed investor group like lenders and brokerages place accumulations of promissory notes that have been secured by mortgage liens into trust, then sell them as securities. In Florida, a property owner can, without the need for either an attorney or realtor, convert their property into personal property with the ease of a signature and notarization. Legal transactions are always better done under the advice of legal counsel, and real estate transactions are oftentimes better afforded with the advice of a licensed agent. However, creating a land trust is simply a matter of the appointment of a trustee to hold the title and certain filings with the Recorder of Deeds and the IRS. When a non-resident of Florida dies while owning property in Florida, issues will arise between states' laws. Regardless if they are from another state or another country, a will may exist in the other location. The claims against Florida land holdings become a complex series of litigation events between courts and attorneys that can consume the wealth of the estate. Also, when a deceased passes, the IRS comes in. They will look for payment of estate taxes, even though an estate may not yet have been settled through probate courts. These ancillary administrative activities and expenses can be avoided or deterred significantly with a Florida land trust in effect. Non-residents of Florida can, by placing title to their real estate in a Florida land trust, avoid ancillary probate administration in the event of death or incapacity. The existence of a land trust under these circumstances permits ease and simplicity in dealing with title to the real property, now personal property. In these cases, it is a given requirement that the land trust agreement and succession interests are clearly stated and should have been notarized at the point of signature. Until 2006, the Land Trust Act left questions as to its appropriateness in light of the Florida Homestead tax exemption for residents. In 2006, the Florida legislature clarified the fact that homestead exemptions are not lost when property is converted into a land trust. Virtually any purchase of property that includes a mortgage lien will contain a paragraph that will call the mortgage due upon the sale of the property to another buyer. This makes sense, of course, because the lender has a financial right to the funds caused by the transaction, regardless of how meager they may be. These lender documents include a stipulation that such transfers stimulate the due on sale clause, unless there are laws that are pertinent. A federal law, the same law that initiated the variable rate mortgages, known as the Garn-St. Germain Act, excluded several life events from the triggering of the due on sale clause of a mortgage lien. One exclusion from due on sale is divorce, and another is the inter vivos trust designations of the IRS.